Are there limitations to res ipsa loquitur? Have you ever wondered if there are limits to the legal principle known as res ipsa loquitur, especially when it comes to auto insurance liability claims? This concept allows a person to assume negligence based on the nature of an accident, even without direct proof of fault. However, it is not a blanket rule that applies to every situation. First, for res ipsa loquitur to be relevant, the accident must be of a type that typically does not happen without someone being negligent. This means that the event itself should strongly indicate that negligence is the only reasonable explanation. For example, if a vehicle suddenly loses control and crashes, it suggests that something went wrong, likely due to negligence. Next, the cause of the injury must have been under the exclusive control of the defendant. In the context of auto insurance, this means the driver must have had control over the vehicle involved in the accident. If the driver was not in control, such as if the vehicle was stolen, then this principle may not apply. Another important limitation is that the injured party must not have contributed to the accident. If the person who was hurt is found to have acted negligently or was partly at fault, this can limit or even prevent recovery under res ipsa loquitur. Different jurisdictions have various rules regarding comparative fault, which can impact the outcome of a claim. Furthermore, the circumstances surrounding the accident must allow for a reasonable inference of negligence. If the facts are unclear or ambiguous, courts are unlikely to apply this doctrine. For instance, if there are conflicting accounts of how the accident occurred, it may be challenging to establish negligence without further evidence. Lastly, just like other negligence claims, statutes of limitations apply. If a claim is filed after the legal deadline, the doctrine cannot be used to revive it. This means that timing is crucial when pursuing a claim. In practical terms, these limitations mean that res ipsa loquitur is not automatically applicable in every auto accident. For example, if a driver claims another vehicle caused an accident but cannot explain how, res ipsa loquitur might help if the type of accident usually implies negligence. However, if the injured driver also acted carelessly, or if the facts are unclear, the doctrine may not apply. Insurance companies often examine these claims closely, sometimes disputing the assumption of negligence or arguing about shared fault. Understanding these limitations is essential for anyone looking to present or defend a claim involving res ipsa loquitur in the realm of auto insurance.